A quorum being present, the subcommittee will come to order. Good morning, Assistant Secretary Main. We're very pleased to have you with us and appreciate your attention to this request. And it's been a little while since we've had a chance to talk, and it's good to, well, I guess I should say it's been a little while since we've had a chance to talk in this forum. But I appreciated the opportunity that we had yesterday as well. You have an important job to do, and we appreciate the time you've taken to participate in this oversight hearing. Today's hearing is timely for two important reasons. First, in just a few days, our nation will observe Workers' Memorial Day, a time to remember the men and women who have been injured or killed at work. It's also a time to reaffirm our commitment to tough, responsible policies that will help protect the health and safety of Americans' workers in the workplace of the 21st century. And secondly, just a few weeks ago, the people of Montcole, West Virginia, and neighbors and surrounding communities observed the 5-year anniversary of the Upper Big Branch mining disaster. There's no doubt that the families of the 29 miners who died live each and every day with the painful memory of this tragic event. Our thoughts and our prayers are with these families and every family that has lost a loved one while on the job. Upper Big Branch is a terrible reminder that bad actors will look for ways to cut corners and jeopardize the well-being of their workers, despite a moral and legal obligation to make safety the #1 priority. I'm pleased that those who had a hand in the Upper Big Branch tragedy are being held responsible. It's taking some time, but justice is being served. An independent report from the National Institute for Occupational Safety and Health underscored why bad actors must be held accountable. The report said, and I quote, "If the Mine Safety and Health Administration had engaged in timely enforcement of the Mine Act and applicable standards and regulations, it would have lessened the chances of and possibly could have prevented the Upper Big Branch explosion." That's why time and again the agency has implemented a number of changes to its regulatory and enforcement practices. The purpose of today's hearing is to examine these efforts and determine whether they serve the best interests of America's miners. We have a lot of ground to cover in a short period of time, including controversial changes to pattern of violations regulations, revised standards governing exposure to respirable coal dust, changes to the agency's citations and penalty policies, and new rules on the use of proximity detectors or on continuous mining machines. Clearly, you've been busy, Secretary Main. As you know, we haven't agreed on every issue. And when we haven't, we've expressed our concerns and encouraged the agency to move in a different direction. However, when the agency, when the agency does take responsible steps to improve health and safety enforcement, you have and will continue to have our full support. Both your agency and this committee share the same goal. We want to ensure strong enforcement policies that are in place so that every miner returns home to his or her loved ones at the end of their shift. I look forward to a frank and robust discussion today and continuing our work together to help reach that shared goal. Again, I'd like to thank you, Assistant Secretary Main, for joining us this morning, and I now recognize Ranking Member Wilson for her opening remarks.
Thank you. Mr. Chairman, I want to thank you for holding this hearing today, this very important hearing. Assistant Secretary Main, I thank you so much for testifying here today. And to our Deputy Assistant Secretary, Patricia Sylvie, thank you for being with us in the audience. This month marks the 5-year anniversary of the disaster at the Upper Big Branch mine, where 29 miners were killed in a preventable coal dust explosion. To the friends and families of these 29 miners, please know that we continue to remember your loss. And at that hearing, we heard testimony on 5 investigation reports that showed the mine operator at Upper Big Branch repeatedly violated mandatory safety standards. Number one, they failed to maintain adequate ventilation, which allowed flammable methane to build up. Number two, they failed to adequately rock dust the mine, which allowed explosive coal dust to accumulate. Number three, they also failed to properly maintain water sprays, which would have prevented the ignition. We also heard how the mine operator concealed its noncompliance. They kept two sets of mine examination books, one for management and a sanitized version for MSHA inspectors. Mine management also routinely warned foremen when mine safety inspectors were on the property, giving foremen the opportunity to conceal unsafe conditions from inspectors. Although mine operators are ultimately responsible for safety of miners, MSHA plays a vital role in holding mine operators accountable. We know that in the 18 months prior to the Upper Big Branch explosion, MSHA issued 692 citations and orders to this mine operator. During 2009, MSHA issued 53 withdrawal orders for unsafe conditions, more than any other mine in the nation. But even this was not enough. Since Upper Big Branch, MSHA has enacted many reforms. MSHA is using impact inspections to target high-risk mines. MSHA has issued final regulations for its most powerful administrative enforcement tool, the Pattern of Violations Sanction, which is intended to bring serial violators into greater compliance. MSHA has issued a final rule increasing the required amount of rock dust to be deposited in underground mines, which will decrease the likelihood of coal dust explosion. MSHA has also issued a rule requiring continuous mining machines have proximity detection devices designed to prevent crushing or pinning miners. The tragedy at Upper Big Branch also brought to light weaknesses in the Mine Act. That is why yesterday I joined with Ranking Member Bobby Scott to reintroduce the Robert C. Byrd Mine Safety Protection Act. This bill gives MSHA the tools it needs to provide greater protections for mine workers. An important provision of this bill provides MSHA with greater subpoena authority. This means that MSHA would have the authority to compel the production of documents and witnesses during an inspection and investigation. Unlike other laws, the 1977 Mine Act gave MSHA limited subpoena authority, forcing MSHA to ask the few states that have subpoena authority for their assistance. By contrast, Congress provided expansive subpoena authority under the OSHA to better protect worker safety. Similarly, Congress provided subpoena authority to the Labor Department under the Fair Labor Standards Act to ensure workers get the wages they are due. Congress has even provided subpoena authority to the Agriculture Department under crop promotion laws such as the Watermelon Research and Promotion Act, the Pecan Promotion and Research Act, and the Popcorn Promotion, Research, and Consumer Information Act. I would ask that we join in a bipartisan effort to enact legislation to provide MSHA with expanded subpoena authority. Although it's only a piece of the Byrd bill, I hope we can reach a compromise on this issue. The Mine Act states that the first priority of the industry must be the health and safety of its most precious resource, the miner. By giving MSHA this investigative tool, we can advance the safety of the miners. By enacting this provision, we also respect requests from the families of deceased miners who have asked for our help in strengthening the law. Mr. Maine, I thank you for all of your dedicated and sincere service towards protecting workers. We are the Workforce Protection Subcommittee, and I look forward to your testimony. I yield back the balance of my time.
I thank the gentlelady. Pursuant to Committee Rule 7C, all subcommittee members will be permitted to submit written statements to be included in the permanent hearing record, and without objection, the hearing record will be open for 14 days to allow statements, questions for the record, and other extraneous material referenced during the hearing to be submitted in the official hearing record. It's now my pleasure to formally introduce today's witness. The Honorable Joseph A. Main is the Assistant Secretary of Mine Safety and Health at the U.S. Department of Labor and has served in this position since 2009. Mr. Main began working in coal mines in 1967 and quickly became an advocate for miner safety and health. Mr. Main worked for the United Mine Workers of America in various positions from 1974 to 2002 and was head of the UMWA's Occupational Health and Safety Department for 22 years. Before he accepted President Obama's nomination, Mr. Main worked as a mine safety consultant. His recent work focused on research and analysis on prevention of mine accidents and disasters, development of training programs and facilities to prepare miners, rescue teams, and emergency responders for mine emergencies and international mine safety issues. He also has had a successful record in taking the chairman of this subcommittee into mines and bringing him out alive, and I thank you for that. I will now ask our witness to stand and to raise your right hand. This is the first time you've ever had to do this. It is a policy that we have now, and so Secretary Main, if you would stand. Do you solemnly swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth? Let the record reflect the witness answered in the affirmative. You may be seated. Before I recognize you to provide your testimony, let me briefly remind you of our lighting system, and you've done this, as you've mentioned to me 25 times, appeared before committees and subcommittees. You know the lighting system. It's a question whether I and my colleagues know the lighting system as well as we should. So we will certainly give you your 5 minutes of time. We won't hold you to strict time because we want to hear what you have to say, but we'll have plenty of opportunity for questions as well. And so I now recognize our witness, Deputy Secretary Main.
Mike.
There we go. Chairman Wahlberg, Chairman Klein, thank you very much for the opportunity to be here. Ranking members Wilson and I believe Courtney was here a few minutes ago. I do appreciate the opportunity to appear here today to report on mine safety and health. We've made progress on many fronts, particularly in the last 5 years following implementation of reforms that began in 2010. The steps that we have taken, along with the industry, are changing, I believe, the culture of safety in a positive way. From 2010 through 2014, 46 miners died annually. That's half of the 96 deaths each year that we're seeing in the 1990s. When employment was roughly the same. At the same time, industry compliance has improved. In 2014, there were 44 fatalities. 16 were at coal mines, which was the lowest number ever recorded in the coal mining industry. 28 were at metal mines, and that was part of an increasing trend that began back in October of 2013. These increases are concerning, especially after years of historical lows in mining deaths. While we still face challenges, including reversing the increases in metal deaths, we are making, I think, significant strides. On April 5, 2015, we observed the 5th anniversary of the Upper Big Branch mine explosion. Our thoughts and prayers are with the families of the 29 miners who perished. We want them and you to know that we are using all of our tools, enforcement, education and training, and extensive outreach and assistance to the mining community to carry out our responsibilities under the Mine Act. In 2010, MSHA revised its pattern of violations procedures and began to conduct strategic impact inspections. The troubled mines receiving impact inspections or undergoing the POV process or both have significantly improved their compliance. We have stepped up enforcement in metal mines, reaching out to the mining community, sharing best practices with them, and asking them to assist as we work to reverse the recent trend of mining deaths. MSHA's other initiatives include the End Black Lung Act Now campaign and a Rules to Live By program, which is aimed at preventing the most common types of fatalities. On schedule, we completed action on about 100 reforms from reviews of MSHA's actions at the Upper Big Branch mine. We built accountability into MSHA's internal process and developed a directive system to provide better oversight of agency policies. We're improving assistance to the mining community. In 2014, MSHA combined its educational field services and small mines program to expand MSHA services, and we now hold quarterly calls with industry trainers. We use technology to assist operators who want to do the right thing, and to support our enforcement for operators who do not, including an online POV tool, which allows an operator to monitor whether a mine is approaching a POV. Last month, we rolled out 2 more tools that allow operators, MSHA and others, to track a mine's compliance with other key safety standards. We want to ensure that stakeholders understand and are aware of our initiative. MSHA's leadership and I have crisscrossed the country to meet with them. Our outreach has led to initiatives that address stakeholder concerns. When the industry raised issues about some metal and non-metal standards, we were able to clarify them, which has improved enforcement, mine safety, and compliance. We reduced MSHA's backlog of contested violations by about 70% from its highest levels in 2010, and revised our pre-contest conferencing procedures, conferencing over 15,000 violations since 2012 as well. An essential component of preventing accidents is to allow miners to exercise their rights to report safety and health problems. Since 2010, MSHA has filed about 185 discrimination cases and 157 actions for temporary reinstatement to help enforce those rights. MSHA finalized a number of rules critical to mine safety and health, including the recent respirable coal mine dust rule aimed at preventing black lung. MSHA has been conducting extensive outreach and support to the industry, and before each phase of the dust rule goes into effect. Since Phase 1 went into effect on August 1st, 2014, through March 31st, 2015, we have seen nearly a 99% compliance with over 41,000 samples collected from mines by operators in MSHA. With the mining community, we have made needed improvements to our mine emergency response capacity and capabilities. MSHA has taken the lead in development of game-changing technologies to make mine rescue safer and quicker, and we will equip our mobile mine sites with them very soon. The state grants program is being funded at $8.4 million at the FY 2015 budget level, and the President's request includes funding for 2016. With that, Mr. Chairman, it's a quick oversight of what we're doing, what the industry is doing on mine safety, and appreciate the opportunity to answer any questions you may have. Thank you.
Thank you. Thanks for your testimony. Now I will recognize myself for 5 minutes of questioning. MSHA finalized the pattern of violation regulation on January 23, 2013. Currently, there are 2 lawsuits pending regarding the regulation and its application. In November of 2014, an administrative law judge for the Federal Mine Safety and Health Review Commission vacated citations against a mine that MSHA placed on POV status. The decision states, and I quote, "Dismissal of the pattern notice rested on 2 grounds. The Secretary's process is inconsistent with procedural due process, and it's also inconsistent with the expeditious resolution of pattern matters." Secretary Main, how do you respond to that statement?
Well, probably a couple things. One is, as we all know, this is an issue in litigation. We are paying close attention to what is going on in the litigation process, and I need to, probably not delve too much into this in terms of the legal issues as before. But what I think it's important for folks to understand is, and I think last year we didn't have any mine that was placed on a pattern violation. And I think this is a standard that should be in place across the country. There is no reason for any mine, I believe, to be on a pattern of violation if they follow the rules and use the tools that we've made to their disposal. There's, we inspect about 13,000 to 14,000 mines a year, and a number of mines that we're seeing that are even subject to the pattern is so small that if you look historically, I think we had 51 mines when we first started our screening process back in 2010. In 2014, there was only 12 mines out of around 13,500 that even met the screening. And because of actions they took, and I think actions that we have taken as well, they met the standard I think is achievable. No mine should be on a pattern violation. If you look at the program that's been in place, I think this has probably been one of the biggest game changers in really reining in chronic violators in this country. The 51 mines that we identified back in 2010, the screening tool that we use is the same one that we used in 2014. There was a reduction of about 76% in the total number of mines that we identified in that same screening. And if you look at, as well, mines that have undergone either the potential pattern violation in the prior system or the pattern of violations program currently, you're going to see a dramatic drop in the violations that we're issuing at those mines, particularly the serious violations. And one of the greater benefits is the reduced injuries we're seeing, cutting the injuries in half after these mines go through the program. So I think we're looking carefully at the litigation that's ongoing and the issues that you have raised as we move forward. But
well, let me expand on that more specifically. Regarding the pattern of violations regulations, stakeholders have expressed concerns that the criteria for placing a mine in POV status was not contained in the actual regulation, which means MSHA can change the criteria at any time. You've publicly stated, and even this morning, that MSHA would seek comments prior to changing the criteria. Future assistant secretaries will not be bound by this statement. So I guess the question comes, how did MSHA determine it was not necessary to include the criteria in the regulatory text?
So, the criteria that we had been using for the screening process is basically the same criteria that we have for the screening process now. And that's what I was referring to when I said the screening process we used in 2014 and the mines that were identified were, the mines in 2014 were identified through the same screening process that we had used. And I understand there was, during the comment period on the rule, an urge by some stakeholders to set a specific standard, but I can tell you one of the concerns that I have in terms of changing or setting that in stone is because of the change of the landscape. We may wake up one morning and say, the criteria that we have established.
But doesn't that leave some type of limbo of concern?
I think if we're staying with the same criteria that we have today, or that we had back in 2014. Okay.
Well, my time has expired. Appreciate the response. Now recognize Mr. Scott, Ranking Member of the full committee, for your 5 minutes of questioning.
Thank you, Mr. Chairman, and thank you, Mr. Main, for all that you do. Your work really means life or death for many mine workers, so we appreciate your work. As the ranking member indicated, we've introduced the Robert C. Byrd Mine Safety Protection Act of 2015, and we'd appreciate whatever analysis that your office could give about the provisions in that act, and if you could provide those as soon as you've had an opportunity to review it, we'd appreciate it.
Okay.
There are a couple of elements to it. One is the issue of subpoena power. As I understand it, you do not have general subpoena power for investigations. Is that true, and why would subpoena power be important?
So under our statute, we have a very, very limited authority for subpoena power. It requires us to call for, hold a public hearing to be able to use it. Having said that, beyond that, we do lack subpoena authority and power. And if you look back at the mine disaster we were investigating back in 2010 and in West Virginia, we had to rely on the state of West Virginia to exercise their subpoena power and authority to seek further questions of witnesses. And, across the country, there's a number of states that doesn't provide that opportunity for us to do that. So, yes, we have a limitation on our ability to use subpoena authority, which during normal investigations, we basically don't have it.
And most other investigatory authorities do have this power?
There's a number of other agencies. I think the ranking member acknowledged some of those today, and I understand there are a number of other agencies that do have that authority.
Thank you. Now, when you find violations, you frequently assess fines. Do you have problems collecting the fines?
So on the collection penalty, I know this has been a discussion for quite some time. At MSHA, we believe we have one of the better collection rates of any federal agency. We're collecting about 90% of the penalties that are final orders of the commission. And I think out of the last 5 or so years, we've met that with the exception of 1 year, which is, I think, it's extraordinary. Having said that, there's still mine operators that make decisions to accrue violations that place miners at risk and do not pay their penalties. There is a mining company, I think it's in Tennessee, for example, that used that model, and at a point in time, they just closed the mine and moved on, racking up several violations, and I don't think they paid a dime in penalties. And we refer to those sometimes as I think the normal person would as scofflaws. So, if you look at someone who may get speeding tickets and throw them in the back seat and decide to move out of the state on a given day and, leave the speeding tickets, there's mine operators that unfortunately do that.
Approximately, let me say, what effect has the budget had on your ability to conduct investigations and inspections?
I'm sorry?
What effect has the budget cuts had on your ability to do inspections?
Well, I think if you go back to the internal reviews that I spoke about and looked at what impact, stagnant budgets or budget cuts have, I think there's a story that is in that internal review about MSHA. When I arrived at MSHA, one of the things that I was learning about the time I was getting confirmed was that the agency had lost so much staff that the average experience of half the inspectors was 2 years or less. I'm sure that was concerning to everybody, sure was to me. And, what had happened was, I think, just with the budgeting process over the years leading up to that, left MSHA with a lot of inexperienced folks, and in particular the mine that was in question in West Virginia where the explosion occurred. We had inspectors who had just received their what we call their authorized representative cards. In terms of where we've been over the last few years, we've been on somewhat a similar cycle, but from where I sit, I try to do everything that I can to make sure that we have monies allocated to staff up the agency, so I never leave another assistant secretary in a spot that I arrived at. And I think that's something that is important for everyone to take into consideration, that an agency like MSHA does have to have the forward-looking budgets, because it takes us about 2 years to train up our inspectors before they ever get their AR card. So it's a concern.
The gentleman's time has expired. I thank the gentleman. I now recognize my good friend, the gentleman from Oklahoma, Mr. Russell.
Thank you, Mr. Chairman, and thank you, sir, for being here today and all of the service that you provided in this field for many years. MSHA has requested $394 million for the fiscal year 2016, and the Office of Coal Enforcement is slated for $175 million of that, while the metal non-metal has almost $94 million. Although the non-metal mines is more than 3 times the number of coal mines, do you believe your budget request will adequately address safety enforcement issues in the metal, non-metal sector?
That is a good question in terms of where we're at with our budgeting process. We continue to look at that on a constant basis. We are trying to be more efficient at MSHA, to utilize staff that we have. We actually have received some help from the coal side to help currently with the metal inspection process. And probably going forward into the future with the changing landscape on the coal side. We probably will be doing more of that to help supplement our work. We're looking at training models to help us more efficiently do that. But as these changes occur in the mining industry, trying to be a more versatile agency. The one thing that I've looked at is trying to keep our authorized representative staffing levels up at MSHA because it takes us 18 months to 2 years to replace someone who loses that. So part of what we'll be doing is looking at how we can use more efficiencies in having, as I say, on the coal side, some help placed over to metal on metal with training that's going to go with that to keep our staff levels up. And I think if you look back at the report that came out of Upper Big Branch where there was a loss, and it was both the coal and the metal side, as far as AORs that had to be, took a couple years to get ramped back up. You can appreciate why we're trying to do that kind of a balance.
Well, I appreciate that. And with your long safety experience and observation of many of these issues over the years, you've highlighted an initiative to prevent fatalities in mining called Rules to Live By in speeches and public announcements. Can you describe what those are and how it's impacting the culture of the mining community?
Sure. This is a program, this is the first program I actually launched when I arrived at MSHA in 2009 was the End Black Lung Act Now campaign, and that was to deal with the disease that we're seeing on the coal side. In general, I believe that we need to have a focus. There's a lot of regulations that the industry has to look at, that MSHA has to look at to see they're in place. And what I felt that we needed was a focus on the core standards that were most commonly found following investigations of mining deaths. Let's make sure that we're looking at the top end. So we took a look at mining deaths over a several-year period. I think the first one was about 9 or 10 years. And identified the standards that was connected with the most common causes of mining deaths. And we launched, I think it was around February, the Rules to Live By. We brought in the mining associations, the NNSGA, different state organizations that were associations work with, labor organizations, and walked them through the program. And there was a change also made with this as we kicked it off, is that I started to develop the training model, that the training we were giving our inspectors to implement this program, we gave the same training program to the industry. I think it's still on our website. But it was to get a focus of the top standards that was linked to the most common mining deaths in the country. We, about 2 years later, updated that, adding another component that dealt with catastrophic type violations that were or could lead to mine explosions and disasters, and that became Rules to Live By 2. And then we took another sweep, a 10-year look back, it was about 2 years ago, of the mining deaths that was most commonly identified again, and we came out with Rules to Live By 3, which actually included a lot of surface standards. So we recently launched a tool about 2 months ago. We had our stakeholders in and created a tool where every mine in the country can now punch in their ID number and see where they stack up in terms of compliance with those Rules to Live By standard. And it's a sort of like a green light, red light. If your text is green, you're on the better half of the industry. If you're on the red, you have work to do. And I know that NNSGA just held a webinar to help, and they've been working with us as well as other associations to really focus attention on it. But the bottom line is these are the standards that's most often cited when we have mining deaths.
Well, thank you. And speaking of red lights, I'm out of time. And thank you, sir. And thank you, Mr. Chairman.
Thank the gentleman. And I recognize the ranking member, the gentlelady from Florida.
Thank you, Mr. Chair. Mr. Maine, you have so eloquently described how subpoena power would help, and but that's just a small part of the Robert C. Byrd Mine Safety Protection Act that was filed, reintroduced yesterday. Since it's named after such an important senator, we called him the miners' senator, Robert C. Byrd. I wonder if you can reiterate to us today what provisions would be the most helpful, other than subpoena power, in the MSHA, to MSHA in protecting miners, the workers.
Well, I think, I've testified before a number of committees since the Upper Big Branch tragedy, and when the bill was, or previous legislation was being crafted or had been introduced, and noted there's a number of issues that would be helpful to provide MSHA with greater tools and improve mine safety. We talked about the scofflaw issue a bit ago, and that's something that has been discussed a lot publicly, and it's an issue that if we had a better tool to deal with that, it would help us rein in mines that decide that they do not want to pay their penalties quicker. I think there's a judge in Utah following a litigation over a disaster that happened there in 2008 that probably best described frustration from that level over the weakness in our criminal penalty process of holding folks more accountable. And I think the statement by the judge, and I don't want to say it because I'll probably get it wrong, but I think there was clear frustration from his voice about the lack of tools that the judge had in his particular tool bag to deal with issues that was of criminal nature that was brought before him. So I think that's something that does strike need. One of the things that I think we have as far as the reporting system with mine operators in this country, a pretty good one. I think there is realization that not everybody fully complies with it. But when it comes to contractors, I think there's a weakness there. And this is one where it would be helpful for us to have more information, more valid information about, contractor man hours and injuries at a work site. And I'm going to give you a bit of a reason why that's probably even more important. If you look at the fatalities that we've been talking about that's occurred over the last 30 or about the last 18 months, we've up to about 42 mining deaths now. A large number of those was contractors. I think actually 10 of the deaths. We had in 2012 the lowest number of contractors ever to die on a job at 5. In 2013, we had 4, which became the lowest. In 2014, we had, I think it was 8 contractor deaths out of the 28 that occurred. And there's a concern that the recent rise that we've seen in the mining deaths, if you look at where most are, what's the top line of those? If you look at the 38, there is, I think, 10 supervisors, 10 were contractors, about 11 or 12 were miners or laborers, and I think there's about 10 of those that was truck drivers. You're talking about 3/4 of the, but the contractor issue that's on the rise there has us concerned, and I'm not sure we know what we need to know about how many is really out there, and all the information about their injuries. So that would be another issue.
That would be another issue. Well, thank you so much. In your remaining 20 months, what are your top priorities for improving protections for our miners?
Well, I think this, for folks who know what I've done for the last 5.5 years, and that is really spending quality time out at mines, out with our stakeholders, having a lot of discussions with them, still trying to figure out what is it we can do more so that everyone miner has a chance to go to work and really go home free of injury and illness every day. And, the kind of things that we're doing, I'm going to give you some examples of our stakeholder outreach that I think has been, and we're still trying to flush out more. 2010, we identified, of course, the top-sided standard in the metal-on-metal sector was guarding. We launched a program, piloted it with the industry. Actually, NNSGA provided mines for us to go out and do actual video shots of what a guarding should actually look like or be. We put it together. We piloted it with a number of the stakeholders, state associations, put it in place. Since 2010, we have dropped the number of citations that we're issuing in orders, 43%. On guarding in this country. It's an effort that we collectively have worked together with them. We've put together a similar effort on fall protection to reduce the number of violations and injuries and illnesses from falls. And we basically adopted in part the OSHA standard, which was something supported by both labor and industry. We've seen an improvement in number of citations we're issuing in that direction. My view is to keep plowing away at fixing things like proximity detection. Miners getting crushed in underground coal mines is replacing really falls of roof as a leading cause. We just implemented the standard for continuous miners that stops this huge piece of machinery in this confined space from crushing a miner when the miner gets too close. We work with the industry to get us where we're at. As a matter of fact, I announced that rule at the Gibson mine, arm in arm with Alliance Resources, who was a pioneer to help us get that rule prepared. I think they had 80-some pieces of their continuous mining equipment equipped with this proximity detection devices. And we're now looking forward to moving on to other pieces of equipment that's on a mining section like scoops, pole haulers, and we're well ahead of the day with that, with the mining industry having, I think, somewhere around 160 pieces of equipment now equipped with that life-saving device.
Time has expired, but we look forward to hearing more of those successes as well, and appreciate that.
Thank you.
Thank the gentlelady. I now recognize the gentleman from Michigan, Mr. Bishop.
Thank you, Mr. Chair. Thank you very much for your testimony this morning. I appreciate your comments and your insight. The coal mining industry has seen substantial change over the past 10 years. The number of coal mines, working coal mines in this country has sharply declined. I'm wondering if you might comment on the impact that's had on the industry itself, and also reflect a little bit about how it's impacted MSHA and the number of inspectors you have, and what may be going on inside MSHA to respond to the number of mine closures in this country.
It is an issue that has all of our attention without question at MSHA. And our role in life is to make sure whatever mines are operating on a daily basis, that we are implementing the Mine Act there in the ways that Congress had intended for us to do. If you look at the boom and bust periods in the coal industry, it's a term that's been stated quite a lot, pretty steep this time, there's no question about it. So as an agency, what we have to be able to do is have a staffing in place to make sure that we're out conducting the inspections that we need to carry out the Mine Act. And what that means in areas where we've lost mines, that we need to be, we need to understand that and be able to make adjustments in our inspection applications. In line with some of the things we talked about this morning, where there has been some flatline budget that has, and it affects every federal agency, not us. It has made some a difference in the funding we have available, which is not the same as it was. I think our budget's about $3 million over what it was in 2012, and with inflationary costs. So the short message is that we are shifting our resources to areas where they're in need. As of late, coal has been out providing support to the metal industry with the increase of fatalities. I think we all look at where the market may go and try to adjust to that as others do. But from a standpoint, yeah, there is a reduction on the coal side, and we're trying to make all the adjustments we can to keep up with that. As a matter of fact, our average inspection hours, which I look at, has stayed pretty standard from 2012, 13, 14. So I know the amount of times, at least the data we're pulling in, that we're spending at mines is staying pretty much the same.
Thank you, sir. Let me switch gears real quick. I have a limited amount of time. Very interested and grateful for, appreciate your focus on safety. One of those areas of interest in this category has to do with refuge chambers.
Right.
And I wonder if you might be able to share with us exactly what that is and also address the concerns raised by the National Institute of Occupational Safety and Health regarding heat generation and purging noxious air in those refuge chambers.
So one of the acts of Congress in the passage of the 2006 Miner Act was to put into motion greater protections for miners during mine emergencies, and the outgrowth of that was the creation of standards that and provisions under the Miner Act itself to require refuge alternatives or refuge units to be placed in coal mines, underground coal mines for miners. These were standards that were basically set back in, I guess about 2007, 2008, and have basically been in place since then as far as the design and use of refuge alternatives. NIOSH is taking a look at some different factors. The heat, temperature is one of those, and there's a few other issues as well that they're looking at. About 2 years ago, I issued a request for information to really take just a thorough look at our whole refuge alternative standards. Is there a better model that we can build? What can we do differently here? And not only that, to deal as well with miners' escape. I have been in a number of mine emergencies myself, going back to Wilburg, which was, we lost 27 miners, and a fire took us a year to find the last miner that was lost. The Greenwich, Homer City mine explosions where miners was lost, and unfortunately they didn't survive. We all know the case of Sago and miners who tried to build a temporary barricade that didn't work, and by the time MSHA arrived, it was too late. I set a course in 2010 to overhaul our mine emergency response program so we can get to those miners quicker if that happens again. And with the initiative that I've launched to really just take a hard look at what systems we need to have in place for refuge alternatives. We just closed a record on that, I think April the 2nd, and that's one of my plans. What do I expect to do before I get out of here, working with industry and everybody, is try to come up with a better model so we have miners with the best protections. But that's a very live issue.
I thank the gentleman. The gentleman's time has expired, and I recognize the gentleman from Wisconsin, Mr. Procan.
Thank you, Mr. Chairman, and thank you, Mr. Main, not only for your work with MSHA, but really your lifelong commitment to mining and to the workers. I know from our conversations you started very young in life working in the mines, and here you are making sure that all those workers can get home to their families every single night, and we really appreciate that commitment. I want to ask, you talked just a little bit about the situation in Utah. I'd just like to ask a little bit more about that. Back in August 2007, when 6 miners were killed inside the Crandall Canyon mine, and then 3 more would-be rescuers, including an MSHA employee, were killed and crushed 10 days later. Following criminal referrals from this committee and the Department of Labor, the U.S. Attorney eventually charged Murray Energy's subsidiary with 2 misdemeanors and assessed a $250,000 fine each, which was the maximum available under the Mine Act. And I think the judge you referred to was U.S. Federal District Judge David Sam, who was actually appointed under President Reagan, who said during sentencing that he was outraged because of the minuscule amount provided by the criminal statute in this matter. So I guess my question specifically is if knowing and willful violation of the mandatory safety standard that causes the death or injury of a miner is a mere misdemeanor under the Mine Act. However, if you make a false statement, it's actually a felony under the Mine Act. Does it make sense that a killing a worker is a mere misdemeanor. However, lying about the matter is a felony. And is there adequate deterrent in that current law?
Two things. I want to first say that my heroes are those who say, I want to volunteer to be a mine rescuer. And at Crandall Canyon, there was those that was engaged in that lost their lives. And if you understood what mine rescue really involved, I think we'd all be taking our hats off in a thankful way. With regard to that particular issue, I think, and I go back to this, I think the judge looked at the case that he had before him. He looked at the circumstances he had. He looked at the mine act of which he had to be controlled by the decisions he made, and found it inadequate. I think that that speaks louder than anything that I could say with regard to the limitations of the Mine Act. The judge was faced with making a decision and felt that he couldn't do what he wanted to do.
So, in the Robert C. Byrd Mine Safety Act, those penalties are increased. Have you had a chance to look at that, and what's your opinion on that?
So, I think the need to have additional tools in our tool bag to deter folks from making decisions that has a judge like the Judge of Utah having to render a decision is what we really need to do.
Gotcha. Thank you. Black lung has taken the life of about 76,000 miners since 1968. Your agency just issued some new health standards in this area, yet some mine operators have sued to try to block the implementation of these. Are the mine operators able to comply with the new requirements, and have mine operators gamed the system by underreporting minor exposures to coal dust that cause this disease?
I have to say this. The reason that one of my first actions as Assistant Secretary was to launch the In Black Lung Act Now campaign was to rid an industry of a disease that I think has long passed its time for action to be taken. And I am a believer that miners are still getting this disease, and just look at the miners whose autopsies were reviewed by the medical examiner in West Virginia. It found 17 out of 24 of those miners, I believe, was a number that was diagnosed with pneumoconiosis. She has 5 years mining experience. This is a disease that, in regards to what Joe may say or someone else, if you look at the 76,000 deaths, as I understand it, those came from death certificates collected, filled out by physicians and medical examiners across the country that CDC-NIOSH collects. So there is some, I think, independence here about the depth of this disease. It is one that, without question, I think we all need to come to terms with. We proposed a rule as part of our In Black Lung Act Now campaign that was aimed directly at changing the way that we make sure that we have dust under control in the mines, because if you look at that data, it says that wasn't happening, okay? And I think the good news is that in phase one, which we spent a lot of time out working with the mining industry, I know Kevin Strickland, who's behind me, and his staff run from one end of the country to the other to work with any mine operator to get them ready for the phase one of the rule. And the great news out of that is, after 41,000 plus samples, half by MSHA, half by the mine operators, we have pretty close to 99% compliance. And I think that speaks highly of both this rule being able to be effectively put in place, and with the industry really stepping up the plate to implement it. I'll tell you this, though, the first part of the In Black Lung Act Now campaign was really education outreach. It was beefing up the enforcement of what we had. And since we put that in place in 2009, every year we were able to drop the dust levels in coal mines in the dustiest locations to historical levels every year. We were able to get in place better dust control systems that was in place more often than they ever had been before. This is making sure these next steps that we keep them there and rid of the disease. And as a personal story, a friend of mine named Mike South was out of the mines, I believe in his 50s, with black lung. Got so bad, Mike and I, getting from that door to that door, you might as well take about 5 minutes, because dragging his oxygen bottle, his lungs were so depleted he couldn't breathe. He got a double lung transplant. Called me from the hospital, just thanking God that someone gave up 2 lungs for him, only just a few months later to die because it didn't work. Chester Fike, who was a poster child to a certain extent for folks who really have this disease, he was an individual, went through the same thing that Mike did, double lung transplant, died, the transplant didn't take. We're really working hard with the industry and everyone to have measures in place that really rids the coal industry of this terrible disease. And we think it'll work.
I thank the gentleman, and I now recognize the gentlelady from New York, Ms. Stefanik.
Thank you, Mr. Chairman. In May 2012, Chairman Klein wrote to you about the injury and illness rate of mine inspectors, and in your reply to his letter, you noted latent hearing loss as one of the primary reasons for the high incidence rate levels. In 2014, the injury and illness incident rate for mine inspectors was 5.2 per 100 employees, whereas last year the industry average was 2.43 per 100. What is MSHA doing to protect inspectors?
I'm sorry, I didn't catch the last part.
What is MSHA doing to protect their inspectors?
So I think everyone probably pretty well understands that the folks that we hire are mining veterans that come to us from the mining industry. I'm a believer that 5-year rule in the Mine Act that we should have at least 5 years mining experience should be the order of the day. So you have some folks that come to work with us has already had whatever experience that they've had. As a matter of fact, that's the reason I have to have drills in my left ear sort of, has changed in, my hearing as well. So we have that, plus we have these mine inspectors going back into these same conditions with exposures. We provide them with the best protections that we can, the best guidance and training that we can, and it's something that concerns us as well. I want our miners to be, our inspectors to be as safe, if not safer, than the mines, that they inspect. So we're looking at a number of things to try to improve that. But I think if you look at both the terrain that they travel into and their backgrounds when they come to us as inspectors, that there are some issues like that we have to address.
Thank you. My second question relates to the consistency among inspectors, which is an issue that we continue to hear from stakeholders about. For example, one inspector may see a hazard and prescribe abatement in order for the operator to avoid future citations, whereas in another case, another inspector arrives and in the same work area finds fault with that abatement and issues a different directive, requiring additional efforts to mitigate to address those concerns. What's being done to prevent these inconsistencies from happening?
I think if you look back, when I arrived here, there was a number of things in place. The Miner Act just went into effect. I think there was an escalation of enforcement, probably the heaviest for the first time in history on the metal-on-metal side. MSHA had just overhauled the penalty system that increased penalties from level of in the $20 million range up to the $140, $160 million range in terms of the aftermath of the disasters that happened in 2006. And as I noted, when I came here, about half of the inspectors that was on board at the time had 2 years less inspections. One of the very first things that we did to, and things have, from 2010 to now, I can guarantee you things have changed. And I just talked to the industry folks out there who I just came from California, one of my last visits, that we talked about how much things have changed because of the actions we have taken. Those included setting up a training program for our frontline field supervisors that are responsible for overseeing the inspections. We put into place, actually in May of 2010, a training program that requires every field office supervisor every 2 years to go through at least a week's training. We are plowing back into inconsistency issues in that training. We have pretty much retrained most of our inspectors on the coal side and the metal side. We've rewritten the handbooks, and I know probably more extensively on the coal side, we retrained everybody to those. I personally am out at mine sites, out meeting with our stakeholders across the country, and we have used that to reconnect the dialogue between our agency and our stakeholders out there. I put back in place a critical piece of helping to resolve issues, which is a pre-contest conferencing process, went in effect in 2012. And what this is when a mine operator receives a citation, instead of waiting till the lawyers line up before the review commission, they can call up the district office, say, we need to sit down, your facts wrong here, and settle those before you even assign a penalty to it. We've done 15,000 violations since that time, and about 55% of those have never went on to litigation as ways to resolve it. These meetings we have across the country in the Midwest with about 8 or 10 aggregate associations. I think I'm getting ready for my 7th trip since I've been here to go out. We just came from Texas about 2 weeks ago, California a couple weeks ago, but we're out basically on the front lines talking to folks, and violations are down, penalties are down, special assessments are down considerably. I think they're about half of what they were in 2010. We know these things are working, and so these our efforts to continue on with our stakeholders and meet and greet and have discussions, have workshops, they've got us where we're at. We're going to continue to do that.
Thank you for the thoughtful answers. I yield back.
I thank the gentlelady. I now recognize the gentleman from Indiana, Mr. Rokita.
I thank the chair. Thank you, Mr. Main. Appreciate you coming back. Been following your work now for a couple years. I've got a couple things I want to get through. First has to do with Silica. In your 2014 regulatory agenda, you suggest that you're going to do Silica rules by October 2015. Now, you don't have to abide by the Small Business Regulatory Enforcement Act, but are you going to consider the impact of these proposed rules on smaller mining operations?
Well, I think the short answer is we're going to consider the impact on the whole mining industry, whether
but not
small
specifically, but not specifically to small mines.
well, small and large, and whatever requirements we have, we're going to follow those. But I can tell you in our rulemaking process, we are a pretty good listener as far as commenters from the public.
With regard to that listening, are you taking a look at the scientific documents that were provided to OSHA during the comment period?
I'm sorry?
The scientific documents that were provided to OSHA during the comment period regarding your Silica regulation.
So, yeah, their rulemaking is separate from ours, but I think the path that we're on is sort of looking to see what's going on at OSHA on their standard.
So will you commit to look at this?
Oh yeah, I mean, we're going to take a good look at the the development of the rule on the OSHA side.
As to the scientific documents that were provided as comments to the rule, can you take a look?
We will take a look at all the pertinent, yes.
Okay. Regarding back to small mines, there's been fatalities in the metal, non-metal division, as you know. Your testimony notes that the small mines consultation program was moved to the Educational Field Services Division. Why the move? And can you provide data demonstrating more outreach to small mines actually has occurred with this move?
Okay. So why did we do it? As I sat down and looked at our resources that we had and how we were deploying those resources, and I started looking at our field operations, what I found out is that we had 2 different staff that was in our training wing, or EFS, Field Services, and our small mines. And our small mines, which was a smaller staff, was not strategically located in places that I thought we ought to be in the country. As a matter of fact, some of the states with a large number of small mines, we didn't even have anybody there. And we had our EFS folks passing our small mines folks to go take care of business. So the logic is, let's make everybody a field service trainer, which means that everybody's a small mines, has a responsibility as well as EFS. The other thing that happened is I had discussions. I've met with the state associations across the country. We've had this dialogue that was ongoing for some time. And so one of the components that I had added to this was, as we formed this new total service to the mining industry, for all of our folks to go out and meet with all the state associations, the labor organizations, the state mining associations, so we could let them know what we were doing and get feedback. And the bigger thing I've asked them, we want to leverage your resources. And I know Joe Casper, who's in the audience here from the NSGA, has been in a few of these discussions where we've been out.
Do you have data? Does your office track those meetings?
Pardon?
Do you have data that you can provide that would demonstrate that outreach?
Yes.
How many associations
yes,
you
I
went
think
to,
we're-
what your outreach visits and
Yes,
paid?
well over 100 outreach visits that we have made, and to put the onus on my whole staff that this is done when I go out and meet with stakeholders, I sort of encourage, if you haven't heard from them, call them and let us know. I can tell you this, that I'm a firm believer that if we can leverage our resources together, because there's a number of these associations has far more contact communication than we do, and we want to leverage what training resources that they have to help us get out to the small mines who have the.
Yeah. Do you keep track of these meetings? I mean, do you write them down?
I'm sure that our
Can
training.
you provide
Yes.
the committee that?
Yes.
How long will it take you to do that?
Maybe a very
Send us
short
a
period
letter.
of time. I mean, it's. I know that
Can you
the
do
last.
Can you do it in 2 weeks?
I think we can do that.
Okay.
Yeah.
I'll put down 2 weeks then.
Okay.
In January, MSHA issued proposed rulemaking changing the citation process and the assessment of civil penalties, and suggested that the proposed rule is designed to eliminate subjectivity in the citation process. There's been controversy around this, specifically with the Mine Safety and Health Review Commission. Do you think that when you assess a penalty, the commission has to abide by it?
So, as you see with all the rules we put out there, proposed rules, we get input from the public, and what we've done is put out proposed changes, and we put out the issues that we've requested comment back on to get some guidance. I can tell you this, before we wrap that rule up, we'll be looking hard at all the comments that came in and making judgments that parallels both the law, our requirements, and really the valued input of the constituents. So I can't really, since it's in a regulatory process, I can't really talk about what we're going to do, because that, you know.
But you're going to have lawyers assess, and I got to yield back, you're going to have lawyers assess the legality of trying to enforce a separate commission to do that.
Yeah, we've noted a lot of comments, you know, one way or the other. If you go back to 2010 when I appeared before the full committee, I believe it was, this is something I had talked about as far as reforms to deal with the backlog that we had. For those that may not be aware, we had a backlog the day I came here of about 80,000 citation orders that was contested. That jumped up from an average that the agency was handling from about 5,000 to 6,000 just a few years before. You can imagine, you know, what was going on. So we started looking at reforms. How can we both resolve the backlog, but forward-looking, make some changes that removes litigation issues and gets us to a better process for mine operators and for miners. Part of this is reforms that we had from back in 2010, and a couple simple ones that when an inspector goes out and looks at a mine, they have to make a decision on 5 different levels of negligence. No negligence, low negligence, medium negligence, high negligence, reckless disregard. Sort of like a yes-no reckless disregard approach is what you'll see as a proposed rule. They have to make a determination of how many miners was affected by that violation, 1, 5, 10, 20, and every one of those added penalty points and added fines. So when we come out with a proposal, you know, I'm an old farm kid, went to work in the mines, yes or no, either folks were exposed or they weren't, and trying to do some of those kind of things to resolve some of what I thought was unnecessary litigation issues, quite frankly. So yeah, there's a lot of moving pieces to the rule, but we're going to really listen well to the public and make hopefully some good determinations.
I thank the gentleman. I now recognize the gentleman from California, Mr. Desaulniers.
Mr. Chairman, I'd like to yield my time to the ranking member.
Without objection.
Thank you, Mr. Desaulniers, for that. Following the Upper Big Branch mine disaster, MSHA began impact inspections at mines with a history of safety problems. When MSHA arrives at a mine site, one of the first actions is to seize the phones or electronic communication. Why does MSHA do this? Is there a problem with operators providing a tip-off? Would stronger sanctions such as a felony deter this kind of misconduct? And what tools do you need to prevent mine operators from giving tip-offs?
Yes, we do that on occasions as part of our impact inspections where our enforcement folks have some concern about advance notice being provided to the workplace to change the conditions before they get there and do inspections. And I think if you look at some of the impact inspection reports that we issue, it identifies that concern quite well. There's been a number of impact inspections that we've done where we've went in, say an underground coal mine, and been able to avoid notice that we were present, and got to the mining section to find the ventilation controls not in place. Ventilation controls are necessary to control the dust that causes black lung. It's necessary to control methane that liberates from the coal seam to prevent mine explosions. Things like that have been evidenced by, by our inspections where we've had to, as we say, capture the phones to get there. And I think that mines that operate like that, although I think they're fewer than what we were seeing back in 2010, still exist. And if you look at some of the more recent examples we've used, I know mines in Virginia and southern West Virginia where we found those kind of concerning issues. So as we look forward, what next steps could be taken as far as other tools to remedy that? I think it's something that is very worthwhile looking at, and I think at least in the bird bill there's some provisions that try to address that. One of them was increasing the attention on criminal actions that could be taken at the end of the day.
Another point I'd like to bring up during this hearing. MSHA has accumulated or referred approximately $72 million in delinquent fines to the Treasury Department. The Robert C. Byrd Mine Safety Bill that was filed yesterday gives MSHA a new tool to address this problem. It authorizes MSHA to issue a withdrawal order to order miners out of the mine if fines are not paid within 180 days of a final order or a payment plan has not been put into place. What is your view about this approach?
A tool like that with the Will Coal Mine that I talked about earlier would probably change the attitude of that mine operator, and it would require them to, it would put them on notice that the violations that you accrue, putting miners in danger, you're going to be held accountable for them, which otherwise left the mine just to rack up violations, not pay any fines, and leave. So yeah, that's a tool that would be helpful there.
You touched on it a bit, but I'd like for you to go into detail about the inexperience of mine inspectors and how budget cuts factor into that, and what caused this problem that MSHA had so many inexperienced inspectors? Did this allow violations to go undetected?
So I think we're in much better shape today as far as the experience of our inspectors than we were back in 2010, and it is something that we are very concerned about, trying to shift whatever resources we can to make sure that we keep our inspectors hired up. If you do slip back to where we were back in 2000, probably about 2009, would have been more difficult than even 10 when I think there was a hiring that took place of about 170 coal inspectors around 2007 that were added to the mix that were not eligible inspectors for about 2 years. So if you look back into that area, you've got to be concerned about not getting there again.
Thank you. Mm-hmm.
I thank the gentlelady. Now I recognize the gentleman from Virginia, and I guess the representative of Assistant Secretary Maine as well, Mr. Bratt.
Yeah, thanks for being here today. I have no questions, so I'm going to yield back to my chairman. Thank you.
If I could just make a comment, I live in just right north of Lake Anna.
Oh, very good.
So this is my congressman.
I was told, and thank you for being here today. And I yield back my time to the chairman.
Would you yield
my time to the chairman. Sorry about that.
I thank the gentleman. Mr. Maine, when MSHA finalized the respirable coal dust regulation, it expanded the NIOSH standards for occupational exposure to respirable coal dust by making significant changes to the medical surveillance program. Did you consider implementing a mandatory medical surveillance program? And I guess the follow-up to that was, what are some of the issues that would need to be considered with respect to implementing such a program?
So I think in the record, you're going to find that there was probably pros and cons about, the mandatory medical. Is that the issue that we're?
Yes, the mandatory medical surveillance program.
Yeah, and coming from a mining culture that I did, and with the issue of black lung benefits, and with the issue of miners afraid that they may not get hired at mines, there has been for years an apprehension that I've seen, outside of all this, of concerns about a mandated chest X-ray that a mine operator may get to see. Mm-hmm. And it has been an issue that's been around for quite some time. I think in a record there was expressions of folks that we should have this as a mandatory requirement. There was recommendations that it should not be. At the end of the day, I chose to leave the law where it was at.
Okay. Take a little bit of time, and it is impressive, the amount of time you and Kevin and your team have spent going out to stakeholders, going out to the mines, meeting with people. Just talk a little bit about what you've seen on the other side of, well, not on the other side of the ledger, in cooperation with the industry itself and the stakeholders, specifically mine operators, mine owners, in developing best practices in the mining operation, working with their miners who, as I've had an opportunity to meet with miners myself, impressive that every day they go to work and do a job that many of us wouldn't do, and yet they enjoy doing it. They want to do that. That's their life. Talk to us a little bit about what you've seen in the industry as best practices, what they're attempting to roll up their sleeves and bring about mine safety.
So about every mine I go to, and I spend a lot of time at mines, it's my favorite place with this job, but if you just go out and see where the rubber's being in the road and what's going on, I think it plays into this narrative that the statistics tells us that we are seeing a cultural change of improvement in mine safety. I was at we took Secretary of Labor Perez to the Cumberland mine in Pennsylvania, sit down and talk to folks. This is a mine that has been able to operate steadily in the Pittsburgh seam, and they attribute their labor management, dialogue and communications and working together as their success story. The next day we were at the Emerald mine looking more at the technological changes at that mine. It's a sister mine to Cumberland. And we got to see one of the most innovative rock dusting systems that the miners working with management created, and maybe on my website soon. They just sent it to me so I could show it. I saw probably some of the best state-of-the-art dust controls on the longwall that was designed by the miners that worked on that longwall in conjunction with management, with a manufacturer, I think, in Germany, that they were able to develop that has them not worried about, the MSHA dust standard because of the work they've done. I was just at two quarries out in California about 2 weeks ago. One of them been in operation since for 100 years. And I believe this is the one that as far back we could never find they had a lost time accident. I went to another quarry that afternoon, had I think one since 2004. I said, what's your secret of success here? They empower the workers, have a good dialogue with the workers, and our training is minimal training to them in terms of how they train folks up. I was at a coal mine in Alabama, one of the deepest in the country, the Jim Walters No. 7 mine a few months ago. And when you look at transfer points in coal mines where the coal comes and dumps, you have a lot of spillage, you have a lot of dust. This is one of the cleanest ones I've ever seen. They re-engineered their whole transfer point to where it's worker friendly. You don't have to take a shovel. You can take a water hose, and the way they designed it to. I mean, these are the kind of things. The Leeds cement plant I was in Alabama, 100-year-old cement plant on its last leg, had all kind of safety and injury problems. New management came in. Management, the steel workers who represented the workers there got together for a local MSHA office. And when I was there, I got to see the benefits of a success story where that 100-year-old cement plant was able to go from the bottom of the barrel, about ready to not be around anymore in this economy, to one of the better plants that the company had. So, you know, there's a lot of things that are going on out there that we're trying to get these best practices sort of like embedded through the industry. And of course, the one of the proximity detection, if it wasn't for companies like Alliance, Consol, that spent the energy and money to build our proximity systems where it was at, we probably would have had a more difficult time putting those rules in.
Well, I appreciate that and your testimony. Thanks for taking the time to join us here. It's been a good update, and I'm sure we have other questions, but that'll come at a time. I now recognize my colleague and ranking member, Ms. Wilson, for her closing statement.
Thank you, Mr. Chair. Very, very quickly. Mr. Chairman, I want to thank you again for holding this hearing and giving all of us an opportunity to hear more about the reforms MSHA is undertaking and how we here in Congress can support MSHA in its efforts to increase mine safety. This was very enlightening to me, and I appreciate all of your testimony, Honorable Maine. I also want to thank our witness, Assistant Secretary Joe Maine, for his testimony today, which I just did. You were fantabulous. This is new to me, and I really learned a lot just hearing your testimony and being exposed to all of the questions today. I feel we're on the right track, and I look forward to working with you in the future. As we've heard, since the tragedy at Upper Big Branch, MSHA has taken substantial steps to better protect the safety of our miners, and that is what our committee is all about. These reforms include beginning monthly impact inspections and finalizing rules that prevent black lung disease and crushing injuries. We applaud the work that has been done and the reforms that have been made. Last year, fatalities in coal mining dropped to 16, the lowest levels in years. However, we cannot forget that the preventable tragedy in Upper Big Branch took place a year after mine fatalities also hit record lows. We also cannot forget that last year, metal, non-metal mining fatalities reached a 7-year high. This reminds us that we must continue to be diligent. We here in Congress must ensure MSHA has the tools and funding it needs to check the mine operators that disregard the safety of miners. We are the Workforce Protections Subcommittee, and the Robert C. Byrd Mine Safety Protection Act provides MSHA with those much-needed tools, including expanded subpoena power. I hope, Chairman Wahlberg, that you and I can discuss legislation that gives MSHA expanded subpoena power. I look forward to working with you on this issue, and I yield back the balance of my time. Thank you.
I thank the gentlelady, and we will certainly continue to work together in the best way possible and where we meet necessary concerns. Again, Deputy Secretary, Assistant Secretary Maine, thank you for the work you do. Thanks for paying attention to our concerns, answering questions, and thank you for being out amongst the field. I know you enjoy being there, and that's a good thing. I think our concerns today are the fact that, yes, we do, as has been mentioned by my colleague, we have a record now of success. We have safety that's been offered. The 16 deaths, or the 38 deaths, I guess, that you mentioned last year cannot be discounted. And yet the continued improvement that we've seen in the last several years has evidenced something that we ought to applaud and celebrate and build upon. I would just encourage continued working with the mining industry themselves on pattern of violation, issues of concern, making sure that the clarity is there. I mean, the efforts that have been undertaken to deal with proximity detector regulations, I think has shown how important and valuable and productive it is in working hand in hand with the industry themselves. We've heard support from the industry on what's gone on there. I think that support is offered and will continue as you expand proximity detectors in other equipment and machine operations. Having stood next to and between the wall and the continuous mining machine, which is an awesome machine from my uneducated evaluation, I can see why there's a need there. And yet to hear that industry is producing and developing that is something that says that there has to continue being a teamwork aspect. Training best practices, having been on site at some of the industry-provided training centers that can be helpful not only for mining operations in this nation, but also worldwide. The impact that could have, again, comes from the private sector. And in working in partnership, public, federal government working with the private sector, I think that can be extremely positive. And then the funding area. As we look at the funds that have been used for the coal and mining operations and the decrease in coal mining operations, which personally I'd like to see that slide stop because there are jobs and there are people that depend upon those mining operations, and I think energy in our country and the world depend upon that as well. Yet we've seen dollars go there that could have gone to the metal, non-metal operations, and I appreciate the testimony you've given about reconsidering and looking at that and shifting dollars to meet those needs. So I guess in conclusion, I would say I think from what I've heard today versus what I heard several years ago, there have been successes, there have been improvements, and that continues. The concern that I'll continue to express, maybe not so much a concern, but a direction from this subcommittee, is to make sure that we work hand in hand, a partnership with business and industry, as well as with the regulator, to make sure it is a partnership that promotes success and long-term growth in this industry. Having said that, I thank you again. I thank my colleagues for your attention to this hearing, and with no other concerns to come for the committee at this time, it is adjourned.